Today the question to be answered relate to a complex situation. The question is, Arthur, who had been drinking heavily, entered Billy's pizzeria to buy a takeaway pizza. Billy took the order and requested payment. Arthur then discovered that he did not have the money to pay for the pizza, and so Billy asked him to leave. Arthur picked up a chair and waved it above his head, shouting, "Give me the pizza." Billy retreated to the back of the shop, scared and unable to escape. After 5 minutes or so of Arthur waving the chair and ranting, Chris the delivery driver returned, having made a delivery. Seeing Arthur, he said, "Okay mate, put down the chair, eh?" and took a step towards him, holding out his hand. Arthur swung the chair at Chris, hitting him and cutting his arm. Chris wrestled the chair from Arthur, smashed it over Arthur's head and then ran out of the door to get help. Hearing the commotion, Daisy, a passerby, assumed that the pizzeria was being robbed. She tripped Chris, who hit his head on the pavement and was knocked semi-conscious. Daisy then sat on Chris and called the police on her mobile phone. Billy, meanwhile, grabbed a pizza slicing wheel and approached Arthur. She said, "If you don't leave now, I'm going to slice you with this." Arthur fled the pizzeria. Advise the parties as to their liabilities and remedies in tort. How to read this question? The rather unfortunate set of circumstances involves many tort issues concerning assault, battery and false imprisonment. There are also potential discussions of defenses that might apply, for example self-defense, or illegality. Ensure you have a clear structure that is coherent, and you consider the liability of the parties individually. The answer should contain, at least, a consideration of the following potential areas of liability. Firstly, the status of Arthur as a trespasser. Secondly, the assault by Arthur and Billy. Thirdly, the battery by Arthur, Chris and Daisy. Fourthly, the false imprisonment by Arthur and Daisy. Finally, any possible defenses. When Arthur entered the premises, he was a lawful visitor under a bare license to enter, be on the premises to make a purchase or communicate. See, for example, Robson v. Hallett, 1967. Robson v. Hallett. In this case, the extent of an implied license was discussed. Facts of case: a police sergeant and 2 constables went to a house where 2 defendants lived in order to inquire about some offenses that had been committed. One of the constables knocked on the door and began to question one of the defendants. Shortly afterwards, the police sergeant came to the door and was allowed into the house by the defendant. The 2 constables were not allowed to enter and remained outside. When the father of the defendant saw the police sergeant, he ordered him to leave. As the sergeant was leaving, the defendant jumped on his back and punched him. When the door opened, the constables outside saw what was happening and went to the assistance of the sergeant. A melee followed and a 3rd defendant, the first's brother, joined in. The 3 defendants were convicted of assaulting the police officers in the execution of their duty. Appeals and cross-appeals were made on the basis that the police officers were trespassers and therefore not correctly executing their duty. Issues involved in matter. Although the judgment resulted criminal convictions, the issue that the court was required to deal with was whether the police officers had been granted license to enter the property and, if so, whether this license was revoked. Decision. It was held that, 1. The occupier of a dwelling house gives an implied license to any member of the public on lawful business to come through the gate and knock on the door. 2. Police officers who lawfully enter premises and whose license to do so is not revoked are acting in the exercise of their duty when coming to the assistance of another officer. 3. Once a license to be on a property is revoked, a person must be given a reasonable time to leave. But at the point that Billy asked him to leave and he refused, his license to be present had been revoked. In picking up the chair and shouting at Billy, Arthur is clearly committing an assault. An assault can be defined as conduct that makes the claimant have reasonable apprehension of an immediate battery, application of force, or the threat to commit a battery. The immediacy of the threatened battery is relevant. Wes J. in Osborne v. H. 1858, noted that immediate in this context meant a present ability of doing the act threatened, for it can be done in an instant. Although the fear must be reasonably held, the claimant must also have a reasonable belief that the battery is able to be and will be committed, as in Thomas v. Nam, South Wales 1986, Thomas v. National Union of Mine Workers. This case relates to assault, and capacity to carry out threats immediately will constitute assault or not. Facts of case: during a set of strikes organized by the National Union of Miners, Nama the defendant, The claimant, who was a miner, wanted to continue working in the mines instead of going on strike. He, along with other miners who also wanted to continue working, had to be bused to the mine so that they could get to work through the pickets. Every day this involved being driven through an aggressive crowd of striking miners, organized by the defendant, who shouted threats towards the claimant and others who were on the bus, in addition to making violent gestures in their direction. However, there was always police at the scene who stood between the pickets and the bus, and in addition, the claimant and the other miners were protected by the bus itself. Issues involved therein. The issue in the case was whether it was necessary for the defendant to be able to carry out his threats immediately for him to be guilty of an assault. Decision: the court held that the actions of the defendant could not constitute an assault as the crowd lacked the capacity to immediately carry out its threats. Capability to put a threat imminently was a necessary aspect of the tort of assault. However, the actions of the defendant were actionable under the tort of nuisance, since they interfered with the claimant's right to use the highway and to attend work without harassment. In this case, while Arthur has not expressly stated that he will do anything to Billy, the threatening nature of his behavior would suggest that Billy could reasonably believe that Arthur would apply some force to her and was sufficiently close for this to be an immediate application. It is highly probable in this situation that Arthur has committed an assault. Arthur is also likely to have committed false imprisonment when Billy remained at the rear of the premises. False imprisonment requires that the defendant directly and intentionally confines the claimant without the claimant's consent or without other lawful excuse. It does not matter how long the confinement is, so long as it is total. Bird v. Jones, 1845, Bird v. Jones, 1845, 7 QB 742, false imprisonment. A. Obstruction of a public road. Facts: Bird, B, wished to cross a section of a public road which was closed off due to a boat race. 2 policemen, D, prevented B from passing in the direction he wished to go, but was allowed to go in the only other direction in which he could pass. B refused to go in that direction and stood in the same place. B raised an action against D for false imprisonment. Issues: B claimed that the exclusion from using a section of the public road which prohibited him from moving in one direction, despite all other directions remaining unobstructed, constituted false imprisonment. Decision: outcome: partial obstruction and disturbance does not constitute imprisonment. There is no lawful excuse that Arthur, including his intoxicated state, could rely on. In relation to Arthur hitting Chris with the chair, it would appear that he has committed a battery. A battery is a direct and intentional. See Letang v. Cooper 1964. Letang v. Cooper, 1965. The defendant ran over the plaintiff in his car whilst she was sunbathing. More than 3 years after the accident, the plaintiff served a writ on the defendant for trespass to the person. By the Law Reform, Limitation of Actions, Act 1954, the limitation period for personal injuries was 3 years. Defendant claimed the plaintiff's action was statute barred. Trial judge held she was entitled to a 6-year limitation period as she had brought her action in trespass, not negligence. Held first that the Act provided actions for damages for personal injuries. For negligence, nuisance or breach of duty, the limitation period was 3 years. Held that the action in question was caught by the statute as any trespass involved a breach of duty. But the Court of Appeal went on to say that to be actionable the trespass had to be inflicted either intentionally or negligently. If it were intentional, then it was a battery. Application of force to which the claimant does not consent, and it can be committed indirectly, for example throwing an object. Case law has suggested that the touching should be of a malicious or hostile character, cf. v. West Berkshire Health Authority, 1989, rather than, for example, constituting horseplay. Chris did not being hit with the chair, and Arthur's behavior could not be described as anything other than hostile. The magnitude or full consequence of the injuries suffered have been intended by Arthur but not consented by Chris, as battery requires only that the act itself was intentional. A. F. v. West Berkshire Health Authority, 1989. Plaintiff was a woman of 36. She suffered from serious mental disability. Since the age of 14 she had been a voluntary inpatient at a mental hospital controlled by the defendant. She had formed a sexual relationship with a male patient. It would have been disastrous for her to become pregnant. Her mother sought a declaration that the absence of patient's consent would not make her sterilization unlawful. held that the judge had been right to grant the declaration sought and the appeal by the official solicitor was dismissed. Now we will discuss about matter of Chris. The fact that Chris then responded with violence himself could similarly amount to a battery on Arthur. However, on pleading self-defense, he is entitled to use force to defend himself, property or another person, such as a response to a perceived threat of battery. The defense exists alongside 53 of the Criminal Law Act 1967. The person must honestly believe that force is necessary and then use only such force as is reasonable. The burden of proving the defense falls on the defendant who claims it, with the defendant having to. Ashley v. Chief Constable of Sussex Police, 2008. In this case, Chris would likely be able to prove an honest belief of a threat of imminent attack and that the belief was reasonable. Satisfy this burden given the chair was being waved aggressively. What is reasonable force will depend upon the circumstances but must be proportionate in relation to the threat. Given actual violence was perpetrated against Chris, his response of wrestling and striking Arthur's head may be deemed reasonable and proportionate given the context of the facts. See comparatively Lane v. Holloway, 1968. In this case, it was also confirmed that the defense of ex turpi causa may also apply in cases of battery as a means to avoid any liability to Arthur for striking him with the chair. Lane v. Holloway, 1967. After an altercation, the plaintiff, aged 64, struck the defendant, aged 23, on the shoulder. The defendant then struck the plaintiff a savage blow in the eye, causing injury which necessitated 19 stitches. Held that even if the fight started out by being unlawful, one party could sue the other for damages for an injury if it were inflicted by a savage blow out of all proportion to the occasion. Plaintiff had not taken on himself the risk of such an injury. As far as matter of Daisy is concerned, Daisy's actions in relation to Chris would almost certainly constitute battery. Her trip was a direct application of force and was unarguably of a hostile character. It is irrelevant that she made a mistake as to the nature of what Chris was doing. Daisy may also be liable for false imprisonment. She is undoubtedly restraining Chris's movement. Chris's imprisonment as such is both intentional and direct. See, for example, Sayers v. Harlow UDC. 1958. Chris is described as being semi-conscious and so may not be fully aware of the fact that his movement is being restricted, but persons need not be aware of their confinement for the tort to be made out. See Murray v. Ministry of Defense, 1988. It is presumed, however, that if a person were unaware of their false imprisonment, any damages award would be nominal. Taking the above into consideration, it would seem that Daisy has falsely imprisoned Chris, and so he would be able to maintain an action against her for both battery and false imprisonment. Sayers v. Harlow UDC, 1958. The defendant was negligent in inviting the plaintiff to use one of their public lavatories. The cubicle had no inside door handle, with the result that the plaintiff was locked in. Held that she was entitled to attempt to get out and the defendant was responsible for the injury sustained when she fell in her attempt to climb out. However, her damages were reduced by 25% because, by putting her weight on such a fragile fitting as a toilet roll, she had contributed to her fall. Murray v. Ministry of Defense, 1988. Mearing was approved and Herring doubted. Facts were that the plaintiff was suspected of having committed offenses involving the collection of money for the IRA, a prohibited organization. Acting on orders, the defendant and 5 other soldiers went to the plaintiff's house at 7 a.m. to arrest the plaintiff. Defendant remained with the plaintiff whilst soldiers assembled other occupants in one room and searched the house. At 7:30 a.m. the defendant formally arrested the plaintiff. Held that where a person was detained or restrained by a police officer and knew he was so detained or restrained, that amounted to an arrest even though no formal words of arrest were spoken by the officer. Thus the plaintiff was under arrest from 7 a.m. to 7:30 a.m. Circumstances of the plaintiff's arrest were such that it was reasonable for the defendant to delay speaking the words of arrest until the plaintiff and soldiers were leaving the house. Although in ordinary circumstances police should tell a person the reason for his arrest at the time when the arrest is made, appeal by the plaintiff dismissed.